Hello, my name is Douglas Pinkham. I am with Pinkham and Associates. We are a dedicated family law firm in Orange County, California. We practice nothing but family law, divorce and family law. This video series is on how to complete your response to a divorce, legal separation, or a nullity case. So if somebody has served you with a divorce, the next series of forms will help you complete the response, your legal response that's required to bring yourself into the case. Okay, thank you, and I hope the following videos are helpful to you. Thank you. Okay, hello folks. We are going to work on the actual response form. That is the FL-120, the first form you're going to need to file a response in a divorce, dissolution of marriage, a legal separation case, or a nullity. Okay, so if you do not have your FL-120 form in front of you, then I would suggest that you get online, print that out. Easy to find, print it out, and then come back and start this video right here again. Or pause it and just come back and get rolling. Some of you folks are listening on this video or watching on this video, and you can actually see the form at the same time. So I'm going to go line by line through the form and help you get an idea of how to fill this form out. Okay, starting at the very top of the form, party without attorney or attorney. So if you're filling this paperwork out yourself, you're going to put, just like every other form, you're going to put your name, your address, and your phone number. If you have a fax number, you can put it where the fax number goes. Then it has a place for your email. If you want to leave your email, you can. You need not if you don't want to. The next line says attorney for, and then name. Just put your own name in there. It's fine if you're filling out the paperwork for yourself. The next line is Superior Court of California, comma, county of. Now you're going to put the county in which you are filing your paperwork, or in the county in which the divorce was filed, or the legal separation was filed, or the nullity was filed. So if it's Orange, you put Orange. If it's Nolo County, or Yolo County, you put Yolo County. If it's San Bernardino, you put San Bernardino County. Okay. So next line is the address, the street address for the court. If you don't know the street address for the court, you can easily look that up online and get that from Google. No problem. Some of the courts have a different mailing address than they do the actual street address. Usually it's a post office box. If you find it, put it in there. If you don't, just put the city and state of the regular street address there. Then it asks for the branch name. The branch name in each courthouse, they have an individual name for that specific courthouse. Like I've said on many other forums, if it's in Los Angeles, there are many other smaller courts other than the central court in downtown Los Angeles, and they'll have names like South Court or East Court, or the family court in Long Beach is the Duke-Majan court. So you want to put the local court name there. Then the next line is the petitioner. So you're filling out a response here. So you're going to be the respondent, obviously. The other party is the petitioner. They're petitioning for a divorce. So you're going to put their name as the petitioner, your name as the respondent, and you want to put the names exactly the way they're named on the petition, or specifically, more specifically, exactly the way they are on the summons that you were also served with, because that summons is the boss of the paperwork and the names and file numbers and that kind of thing. The next line is the box where it says response, and there's a little check mark possible where it says and request for. So if you're also asking for a divorce or a legal separation or a nullity, then you can put that. And by the way, I did skip over this. It didn't occur to me until I'm now seeing these also. This is also the response form that you will fill out if there's a dissolution of a domestic partnership, or a nullity of a domestic partnership, or a legal separation of a domestic partnership. And you're going to mark those boxes accordingly. Off to the right, you're going to put the case number, and the case number comes off the summons or the petition. Okay, then you're going to mark the box, the appropriate boxes for which you're responding to. If you're responding to a dissolution of marriage, you're going to mark that box and the marriage box. If it's a dissolution of a domestic partnership, you're going to mark that box. So just mark the boxes accordingly, and then we move down to legal relationship. It's number 1, legal relationship. If you are married, you're going to mark the "we are married" box. If you're a domestic partner in a domestic partnership that was established in California, you're going to mark B. If you are in a domestic partnership that was not established in California, you're going to mark C. Then we go on to number 2, residence requirement. This residential requirement means that, and the rule is that one of you must have lived in the state of California for 6 months, and the county in which the divorce or the legal separation was filed for at least 3 months. So if you have lived in the county in which it's being filed for 3 months and the state of California for 6 months, then you can mark respondent. If you both have, then you can mark both the petitioner and the respondent. Okay? If only the petitioner has met those requirements, mark the petitioner only. Okay, so then B doesn't require the 3-month time frame. It just says our domestic partnership was established in California. Neither of us has been a resident or have a domicile in California to dissolve our partnership here, but you still want to dissolve it here. You can mark B. Number C, or letter C, is we are the same sex, comma, we were married in California, comma, but currently live in a jurisdiction that does not recognize and will not dissolve our marriage. So that's another state that does not recognize same-sex marriages. And if you are now living in one of those states, you can still get your marriage dissolved here in California if you were married here by marking C. And then if you marked C, you're going to put the city and state where the petitioner lives and the city and state where the respondent lives, where you live, in the box, the appropriate boxes. Next is number 3, statistical facts. A1 is the date of marriage, and you're going to mark A. If it's a marriage and a divorce of a marriage, then you're going to put in the date that you were married. Number 2 is the date of separation. Keep in mind, under California law, the date of separation is that date when one of you told the other one, this marriage is over, I don't intend to continue the marriage in the future, and you do not ever get back together after that date. If you have gotten back together after you broke up and said those words, then said them again, it's the later of the 2 dates. If you've done it 10 times, not uncommon, then it's the last time you broke up and told the other one, this marriage is over, I don't intend to continue this marriage into the future. Just as a side note on that, if you have separated and you later want the court to really understand that you are separated and living apart, then certainly living in a separate home will help make that argument stronger. Separating your finances so that you are living financially separate from each other. You know, those kinds of things. Anything you can do to further show that you are separated will further go to argue that data separation. If you guys are still living together, still living in the same room, still sleeping in the same bed, you know, even if you're not having sex, but you still, you know, do all your banking together, you still pay all your bills together, you still have dinners on Sunday night together, maybe you took a weekend vacation to San Diego together, you're going to have a hard time showing that you're truly legally separated from your spouse with those facts. It is a totality of the circumstances kind of argument. So everything that's going on in your life goes into the argument of whether you are or are not legally separated. So you want to keep those things in mind. If you're trying to show that you're legally separated, then you're going to want to be living as separate and apart as you possibly can. Just a side note. All right. Then in number 3, it's A3. Under statistical facts, it asks for the time of the date, time from the date of marriage to the date of separation. So this is the length of your marriage. So if you got married January 1st, 2015, and you got separated June 30th of 2016, then that is going to be a 1-year, 6-month marriage. Okay, quite simple. All right, now, under statistical information B, if you registered a domestic partnership with the California Secretary of State or the equivalent in another state, you want to put the date that you, well, first of all, in the bigger space to the left, you're going to put the jurisdiction where you did that. So if it was, you know, Nevada, or if it was, you know, Oregon, wherever it might be, New York State, you put that in there. And then on 2, date of separation, you're going to put that date in there. And then just like in the marriage separation above, you're going to list the amount of time between the register of the domestic partnership and the date of separation, years and months. Okay? Now, we're going to move on to number 4. This talks about minor children of the marriage or of the domestic partnership. So, if you have adopted children or if together, or if you have children together, you're going to mark B. If you don't have any children of this relationship, mark A and move on to the next section. But if you do have children, you're going to mark B. Then you're going to list the child's name where it's appropriate. Okay, and so you're going to list the name of the children, one after another. Then you're going to list their appropriate birth dates next to their names. Then their appropriate age and sex, male or female, to the right, and move on. If you need more space, I think this gives you room for 4 kids. Actually, it gives you room for 5. If you have more than 5 children, you're going to mark 1 underneath there, and you are going to use a separate sheet of paper. You can even use a regular lined piece of white paper or yellow paper and write down the same information for your 6th or 7th, 8th child. And you're going to mark that B to show. And at the top of that page, that attachment page, you put attachment 4B. All right. Now, let's say, for example, mom is pregnant at the time of this dissolution. Then you would mark 2, a child who is not yet born. All right. Then there's some notes there you should be aware of right below there, C, D, and E. It's just telling you that we're going to need to attach another form. We are going to attach that FL 105, and there's another video that's going to show how to fill that out. Okay. If in this marriage there was still one or the other of you signed a voluntary declaration of paternity on a child, then you'll want to mark is or is not present, and then you'll want to attach that if it exists. That's pretty rare in a marriage. All right. Going on to page 2. At the top of page 2, it has a place for the petitioner's name and the respondent's name again. Put those in there appropriately. On the right, it gives a place for the case number. Write that in there. Then number 5, legal grounds for your action. Number A, or letter A, says respondent contends that the parties never legally married or never registered as a domestic partnership. So if you believe that this was never a valid marriage because it was never registered or you never legally married, you can mark A. B says respondent denies the grounds set forth in 5 of the petition, which means that you are legally married. So if you do not believe that you're married, you're going to list, you're going to mark B. Now, before you mark that, go to the petition you were served with and look at number 5 and make sure that you disagree with all of those contentions. If you do, then mark B. If this is a standard response and you were married, you know you were married and you're getting divorced and you want to file a response to this divorce or to the nullity of marriage or legal separation, then you're going to mark C and then check the appropriate boxes below. If it was a regular divorce, you're going to mark divorce. Number 1, divorce, and if it's a legal separation, you're going to mark legal separation right next to that. And then irreconcilable differences, if that's the reason for, in your mind, for the divorce. You could also mark permanent legal incapacity to make the decisions. You're going to need some more advice if you're going to mark B. So if you feel like you need to mark B instead of just simple irreconcilable differences, contact an attorney and get some advice on that. Okay, next, if it's a nullity of marriage, you're not going to mark the divorce stuff, obviously. You're going to mark nullity of marriage. And if it's being nullified because you actually found out you were married to somebody that you are related to, that is, if you're related to that person, then that would be incestuous, unless it's a distant relative. Again, if you're going to mark that one, get some specific advice on what the how close a relationship, familial relationship, is required to be incest. Very rare, but if it comes up, you're going to need some more legal advice anyway. Contact an attorney. If you're asking for a nullity because the other party turns out that you were married or the other party was married at the time that you got married, then that would be bigamy. Married to somebody else, you can't be married to 2 people at the same time. So if that's the case, then you're going to mark bigamy. If look at number 3. Number 3 lists nullity of a voidable marriage or domestic partnership based on respondent's age being too young to get into that kind of a contract, under 18. Prior existing marriage or domestic partnership, unsound mind, or if you were forced into getting married by fraud or by force, or if you want to get a nullity due to physical incapacity. Again, anything under number 3, both actually, number 2 or number 3, call and get some advice from an attorney if you're going to mark any of those. Just telling you. All right, moving on to number 6. If you have children, you need to mark something in this section. Legal custody of the children. If you, this is your response. So if you want legal custody of the children and you don't want the petitioner to have legal custody of the children, you would mark the box that has respondent. If you want it to be joint legal custody, you would mark joint. Under this circumstance, I have no idea what other would even be. If you think it's something other, give an attorney a call and get some advice on that. I've never marked that box in my career. Physical custody of the children, too. Again, if you want physical custody, you're going to mark respondent. If you want petitioner to have the physical custody of the children, you're going to mark petitioner. If you want it to be joint custody, you're going to mark joint. I highly recommend that you mark joint at least on that box and worry about figuring out what the specific timeshare and the schedule and the visitation and custodial schedule would be later. All right, visitation. If you're asking for custody to you, then you can mark visitation to the other party. All right, if you want to include an FL 311, 312, 341C, 341D, 341E, or put some kind of a custody and visitation schedule on just a handwritten or typed out attachment, you can attach that as 6C number 1. You don't need those documents attached, but if you want to be very specific about the custodial schedules that you want, you can use those forms. They're not difficult to fill out, pretty self-explanatory. You do not need, it's not necessary to fill them out for your response. All right, number 7, child support. There's nothing to fill out in this box. They're just giving you a warning that if there's children, there will be child support. Okay, spousal support or domestic partner support. The first box, 8A, says spousal support or domestic partner support payable to, and if you want spousal support to be ordered in this case at some time to be ordered to be paid to you, then you're going to want to mark A and then respondent. All right? I recommend that you mark that, even if you are the higher wage earner, because nobody knows what's going to happen next month. I always tell my clients when they're sitting in front of me, God forbid something should happen, but you could, even if you're the larger wage earner, you could step off the curb, get hit by a bus, and your partner could get, could win the lottery at the same time, and ultimately you could get spousal support paid to you. If without that box being marked, A and to respondent, you couldn't get it. You'd have to refile, amend this response to get it in the future. So simpler just to mark it now and be done with it. A lot of people don't want to mark these boxes this way because they're afraid that it's going to anger the other party. Look, folks, you're going through divorce. The other party already filed divorce against you. You guys, for lack of a more cordial way to put it, you guys are enemies. You guys are legal enemies. That doesn't mean to say that it needs to be ugly or, be dragged out forever, but you guys are on opposite sides of a legal battle. And in a divorce especially, if the petitioner gets more time with the child, the respondent's going to get less. If the respondent gets more money from a bank account that you guys share, the petitioner's going to get less. Every interest you guys have in these cases, virtually every interest you have in a divorce case, legal separation case, or the like, is going to be opposite of the other person's interest. So that inherent conflict, you guys are legal enemies, for lack of a better way to put it. So it's going to be difficult under most circumstances. Again, let me preface, or let me state now, I do a lot of mediations, and I have both parties sitting here, and it does not ever have to be ugly. Even if one person gets a little more money from a bank account, that person could also be giving up a more valuable vehicle to the other person, so it really evens out. So even though your interests are absolutely opposite, generally speaking, as the other party, it does not need to be ugly and drawn out forever. So just a bit of information. So the next one is 8B. If you want to ask the court to terminate the jurisdiction to award spousal support to the other party, then you can mark B, and in this case you would mark petitioner. If you want to take the super easy route and not anger anyone, not take a chance of angering anybody, you can skip A and B, mark C, reserve for future determination of issue of spousal support to, and then you can mark yourself, respondent. That would keep it as nice as you possibly can. And let's other. If you have some other requests with regard to spousal or domestic partner support, You can mark other and then write it in there. Again, I would suggest that you talk to an attorney and get some legal advice on anything that you plan to put in the D other box before you do it and file it with the court. Keep in mind that it's always, always easier. You can give me a call and hire me to help you out or not. You can call another attorney to help you out or not. The point is, I need you to understand that this is a fact. It's always, always more expensive to hire an attorney to undo a problem that you've made and redo it the right way than to simply hire someone to help you do it right the first time. Just my little tidbit, just my 2 cents on that. Moving on to section 9, separate property. So this is an interesting section, and I'm going to pull something up on my desktop here. All right, so this is a section 9. There are 2 boxes on the left there to mark A and B. A says there are no such assets or debts that I know of to be confirmed by the court. And then B is confirm the separate property that I've listed below, basically. You need to understand what separate property is. Separate property is any property that you owned before you got married. It's any property that you acquired after you separated from your spouse. It's also anything that you acquired during the marriage by way of a gift, even from your spouse, or by way of a will or a trust or, inheritance. That's all separate property. If you have received money, real estate, $1,100 bicycle, some gold coins from grandpa when he died, whatever you have, you're going to want to list that under the separate property section. And you're going to want to mark B, then the following list that property in that large box on the left, and then where it says confirm to, you're going to want to put that to the respondent. Okay, we've finished with, and a little more on the separate property thing real quick. It's virtually impossible that you didn't own anything before you got married. So even though it might not be serious and there might not be anything of serious value, there is some things that you own that is your toothbrush is your separate property. Your clothing is your separate property. That doesn't mean you absolutely need to list your toothbrush or your clothing. However, if you mark A, there are no such assets or debts that I know of to be confirmed by the court, you're literally saying, I don't own anything. I don't own any clothing. I don't own a toothbrush. So it is better to mark B than the following list, and then list some items that are definitely yours that you want back. Now, keep in mind one other thing, too. Let's say, for example, you were working at your job for 5 years before you got married, or even 6 months before you got married, whatever it is, and you were putting money into a 401k, or you were saving money away from work in an IRA, or you had stocks before you got married. Let's take that 401k because that's an interesting. Oh, those are your separate property, by the way. Those things that you own before marriage, that's your separate property. But let's take the 401k because that can get a little tricky. Let's say you were working at this job for 6 months, or let's say 5 years before you got married, and let's say your 401k was worth $22,000 on the date of marriage. Then let's say you're married for 12 more years and you put another $120,000 more into that 401k. So at the end of your marriage, it's worth $140,000. You need to understand that first $20,000 that you earned before marriage, that's still your money. That's still your separate property, and you would want to list that here. So keep that in mind. Okay. By the way, just as a side note, that same theory is true with regard to a house that you later put that you're later putting money into during your marriage. It gets mixed and it gets messed up a little bit with community property funds and community property contributions and that kind of thing. So that law gets tricky. But you need to understand that there's at least some part of that home that's yours alone. So that's an interesting thing that a lot of people don't know. We're moving on to page 3. At the top again, petitioner and respondent, list those correctly. This is a response, so obviously you're filling out a response. You're the respondent again. Then you're going to put the case number to the right. Then we're going to move on to section 10, community and quasi-community property. All right. So again, if you were married for more than a few months, it is highly unlikely that you have no community property. That means community property defined is presumed to be anything that was earned or acquired during your marriage. So from the date you got married to the date of that separation, you put on the front page. All during that time, if anything that you acquired is presumed to be community property. It gets confusing if you had money before and you bought something during the marriage with money that you had from before marriage, you know, and that kind of thing. If you have tricky issues like that, talk to an attorney, because this is not one of those areas where it's exactly common sense or intuitive in how it works. So if there's some confusing issues there, get some advice from an attorney. So my point was 10A is probably not the correct box to list or to mark, because that's saying that you acquired absolutely nothing during your marriage. You did not earn a single dollar during your marriage. You did not open a bank account or buy a stock or buy a couch or buy silverware or buy, you know, anything during your marriage. So it's much more likely that you're going to mark B, which says determine rights to community and quasi-community assets and debts. All such assets and debts are listed, and then you can either fill out an FL 160 form, which is a property declaration that has the item on the left and then the values and who, and then there's a petitioner column and a respondent column, and you can put the item of value in that column. Or you don't have to fill out that form. You can list your community property items here. You don't have to put values on this form. You just mark B and as follows, and then list your items. Now, if you absolutely, first of all, if you own real estate, even if you own 10 pieces of real estate, you must, for other legal reasons, and you can call an attorney and get some advice on this, but I'm telling you, you need to list the real estate, the community property real estate for sure, which is also true on your separate property. Make sure if you own real estate and you owned it before marriage that you list any real estate positively. But so you're going to want to list the real estate for sure. Anything of any reasonable value. If you've got anything that's, you know, above a few $100s, you might want to list that. Now, if you don't want to literally go room by room through your house and list everything you own on the planet and all your bank accounts and all your investment accounts and everything else, there is some standard language that can cover you. And some language we use when we don't have time, when we're initially filing this documentation to fill this out, is I will put in here, okay, before I tell you what that language is, you need to understand what's going on here is you are giving, by listing this property, you're giving notice to the other party and to the court of what the community property is, and you're basically giving permission to the court to divide this community property. If you own a grand piano that you just bought and it's worth, you know, and it's worth $15,000, this incredibly beautiful piece of furniture, and you bought it together and it's community property, and you bought it with money that you earned during the marriage, and there's just no confusion, this is a community property 50-50 item, but you don't list it here, the court does not have the authority to cut it up. So theoretically, that piano is going to belong to both of you after the marriage, because the court doesn't have the authority to divide it up. Yeah, there's potentially a way that it could sneak by in your judgment and nobody noticed that you didn't name it, but don't try to do that. Don't be foolish. If you've got items of significant value like that, you need to list them. You absolutely need to list them. In addition to that, I use language in my responses and my petition, basically, also, by the way, that reads like this. And what we do is you just take out the items that don't apply to you. And it basically lists the bulk of assets that you could possibly own. And I'll read it. I would put in there the family home located at, and then the address, and then a comma or a semicolon. I would list any other real estate that you own by address, specific address, comma. Then I'd put automobiles, boat, wave runner, motorcycles, airplane, art, furniture and furnishings, electronics, tools, dogs, cats, collectibles, bank accounts, retirement accounts, insurance policies, stock options, annuities, pensions, 401ks, IRAs, investments, businesses including, and if one of you owns a business or multiple businesses, you want to list those businesses, credit cards and other debts, jewelry, cash, and additional property, the full extent of which has yet to be ascertained. Now, if you don't own an airplane, obviously take it out. If you don't own any boats or wave runners, take them out. If you own some other kind of an investment vehicle, write it in there. If you own, a travel trailer, list it. If you own a boat trailer, list it. This just gives you an idea of the kinds of things that you need to list if you've got them. And you can be a little vague about it. You don't have to be too specific about, you don't have to put VIN numbers on a vehicle. You don't have to put, you're just asking the court to have the jurisdiction to divide your property. So you want to list it in general terms here. Okay, then we're going to move on to other requests. 11A is asking for the other party to pay for your attorney's fees. Or if you want to be kind, you could mark yourself to pay attorney's fees for the other side. So be careful here. You don't want to mark the wrong box. If you want to ask the court later for the right to get the other party, well, in this case, we can just name it. If you want the petitioner later to pay for your attorney's fees, then you're going to want to mark A and petitioner, so that the sentence would read attorney's fees and costs payable by petitioner. Okay? If you are the respondent and you changed your name as part of this marriage and you want your former name restored, you can mark B. You should mark B, and then you're going to list your name in specifics at the end. If you have a middle name, do your full first name, your full middle name, and your full last name that you want your name restored to. All right? And then later, that can be put on the judgment to make it a court order that your name returns to that name. All right. If you have anything other that you want to list in here, and there are some things that attorneys put in there. I don't typically put anything in there. But if there's some other straggling issue or item, you can put it in there as another request, as other requests. Then you are going to date it, and you're going to write your name where it says type or print name, and you're going to sign to the right where it says respondent. Now, keep in mind, you are also acting as your own attorney, so you might want to just put your name and the date twice and sign twice. You don't necessarily have to do that, but you are acting as your own attorney, so it would be proper to sign on both and list your name and date on both on the left and sign both on the right. All right, folks, that is the entire response. There are other documents you need to file with regard to filing a response in California, and those videos will follow. Again, my name is Doug Pinkham. I hope this video was very helpful for you. Thank you very much for listening.